So the League is now 100 years strong this year. The National League was founded in 1920, 6 months before the ratification of the 19th Amendment. The State League of Women Voters of Virginia was organized a few months later, and the Williamsburg Area League began in 1962 as the first integrated local league in Virginia. And we're very proud of that history. We have more than 700 leagues around the country, and including Virgin Islands, Hong Kong, and DC, 14 local leagues in Virginia, and men have been members of the league since 1974. I'll take this opportunity now for a public service announcement. We hope that all voters will be wearing this I voted sticker on November 3rd or before. These important dates will be repeated at the end of this webinar as well as on our website. The important ones to remember if you need to register or to update your address if you've moved is October 13th. October 23rd is the deadline to request an absentee ballot that will be mailed to you. Halloween to visit your local registrar's office in costume or not, to vote, but with a mask, to vote early in person. And finally, the day that no one should ignore, November 3rd. You can get a head start and request an absentee ballot right now, actually. The issue of voting rights in the US has been contested throughout our country's history. Today, we will look at what our founding fathers envisioned, how changes occurred through the next 250 years, and finally, what you should know about the upcoming election changes in 2020. When we scheduled this topic a few months ago, longtime Congressman John Lewis was still with us. We celebrate his perseverance in the fight for voting rights and civil rights over his many decades. We hope that today's webinar will help you to value the sacred right of voting as much as he did. Finally, if you have questions, we hope to have time at the end. Benjamin Franklin understood the power of voting. He said, "They who have no voice nor vote in electing of representatives do not enjoy liberty, but are rather enslaved to those who have votes." It is definitely a myth that Americans were given their voting rights. We have fought for them to be expanded since the Constitution was written. It's been a bumpy ride. Every advance seems to be followed by conflict. The power of voting is not to belittle. Our founding fathers set property requirements for voting that we would not tolerate today. John Adams had such thoughts too, and obviously he didn't listen to his wife, Abigail Adams, who was famously remembered for saying, "Remember the ladies," as he set off for the Constitutional Convention. Does our democracy come with an expiration date? Some of our founding fathers had some interesting thoughts on this. John Adams was no stranger to sensational quotes such as this one. "Democracy, while it lasts, is more bloody than either aristocracy or monarchy. Remember, democracy never lasts long. It soon wastes, exhausts, and murders itself. There is never a democracy that did not commit suicide." Rather a somber quote. Often today we celebrate and sanctify the founding fathers and the Constitution that's the bedrock of our republic. But when it comes to voting rights, most of the founders were far off the mark for how to see the right to vote today. Adams was quite leery of all Americans voting and fearful that the common folks could not be trusted since they were not educated men like himself. The public have come to almost worship our Constitution as that which holds us all together. Many have strong opinions about its meaning, even though constitutional lawyers and Supreme Court justices do not always agree. The website of the National Constitution Center was a powerhouse of information that helped me learn so much about the Constitution in preparing this webinar. I highly recommend that you visit it, and their interactive Constitution provides conservative and liberal interpretations of each part of the Constitution, including all the amendments. Now we look back to 100 days in Philadelphia at the Constitutional Convention. Very hot days, probably very similar to today. 55 delegates eventually arrived, but only the delegates from Virginia and Pennsylvania were there when the convention started, and only 35 attended on a typical day. This was 11 years after the Declaration of Independence. and our nation was in debt, unable to pay the long overdue wages of revolutionary soldiers. The original goal was to fix the Articles of Confederation of 1781 that had vested almost all power in individual state governments. It helps to know a little bit about who these folks were. 21 were military officers back from the Revolutionary War, 34 were lawyers. Ben Franklin was the oldest at 81. He had to be carted in there in those famous pictures you see. 4 were in their 20s. 29 of the delegates held college degrees, and about a third of them owned slaves. The delegates did not even refer to the meeting as a constitutional convention. The spotty attendance prompted Washington to write that the Constitution was signed by, quote, 11 states and Colonel Hamilton. Here's another rather eye-opening statement from Jefferson, perhaps because he was not in Philadelphia during the convention, but he was serving as minister to France during the months when the Constitution was drafted. He said a democracy is nothing more than mob rule, where 51% of the people may take away the rights of the other 49. When Jefferson received a copy of the completed Constitution from James Madison, he was unable to contain his unhappiness at the absence of a Bill of Rights or the lack of term limits for members of Congress. Others who were not at the convention were John Adams, Samuel Adams, John Hancock, and Patrick Henry. And to be accurate, the word democracy does not appear in the US Constitution because we're actually a constitutional republic. Did you know that our Constitution is the oldest and shortest in operation in the world? That of India's is the longest. James Madison got credit for drafting the document, but it was 4 long months of compromise that hammered it out, and all delegates did not support it. Only the 39 delegates, who represented 12 states, everybody except for Rhode Island, remained through the 4 months and signed the Constitution. 5 of the states were slave states, when slaves comprised about 35% of the population of those southern states. And this convention definitely did not end slavery. This last bullet is kind of interesting. 38 states allowed non-citizens to vote at some point, until as recently as 1996. Congress then passed a law prohibiting non-citizens from voting in federal elections. Virginia ended the voting rights for non-citizens in 1850. But today, 11 municipalities in Maryland and 1 in San Francisco still permit non-citizens to vote in local elections. Slavery was obviously a point of contention at this convention, but we'll never know exactly what was said. The delegates agreed to observe a strict rule of secrecy, with nothing, quote, spoken in this house to be printed or otherwise published or communicated. In our 21st century world, this matter of proceeding on a matter of such monumental importance would be instantly rejected as unacceptably pretentious and undemocratic. But the rule of secrecy gave delegates the freedom to disagree, sometimes vehemently, on important issues, and to do so without pandering to public opinion that so often marks political debate today. And it also gave delegates the freedom to change their minds. Frequently, after an evening of convivial dinners with a superabundance of wine, the delegates would return the following morning or even the following week or month and reach agreement on issues that had previously divided them. Compromising at that time was perceived as an attribute of statesmanship rather than a sign of weakness. How times have changed. Here are some interesting tidbits from the National Archives about the delegates from Virginia. I found that 4 of the 7 Virginia delegates had a Williamsburg connection. But just to briefly go over that, James Madison, whose journal was the best single record of the event, spoke more than anyone else. George Mason didn't sign the document because it didn't have a Bill of Rights. James McClurg got to be a delegate only because Patrick Henry refused to go, saying, "I smell a rat." Edmund Randolph didn't sign because he was wary of a one-person executive and wanted the possibility of amendments. George Washington, we know enough about him. He was the president of this convention. George Wythe left early and played an insignificant role. And last on the list, John Blair was a quiet observer. He never said anything at the entire convention for 4 months. And he remains quite quiet today at Bruton Parish Church. In this August 1789 political cartoon about the ratification of the Constitution, North Carolina is being guided into place because they wouldn't ratify it until November of that year. Rhode Island is the state that really had misgivings. They refused to send delegates to the convention, and their opposition was partly due to their fear of federal taxes and also their Quaker opposition to slavery. They didn't ratify it until May of 1790, and then only by a vote of 34 to 32. On September 12th, just 5 days before the convention was to adjourn, George Mason proposed that the nearly completed draft of the Constitution be prefaced with a Bill of Rights, but the delegates did not embrace that proposal at all. Not a single state delegation supported his proposal. But here is the timeline on the required ratification, which was needed by 9 states. Only a few months after the convention ended, Delaware was the first state to ratify the new Constitution. New Hampshire became the required 9th, but all was not over at that point. 4 days later, Virginia ratified it, but with request for 20 changes. And North Carolina and Rhode Island were ineligible to vote because they hadn't ratified the Constitution yet. But the debate on amendments had already begun. Looking at 1788 and the first presidential election, who could vote? When the Constitution was ratified, it made no mention of a federal voting age. It was up to the states. In most cases, you had to be 21 years old and a white, male, land-owning Protestant to vote. In some states, there was even a nominal religious test for voting. 4 states allowed freed Black men to vote. 4 northern states allowed freed Black men to vote. And women in New Jersey who were not married and thus could own property could vote for a few years until that was taken away. And there was only 12% of the population voted that year, which is not surprising considering all of the demands imposed by farmers. 2 months passed after the election before the votes were counted, and Washington was then notified that he was elected president. It took him a few months to get up to Philadelphia to be sworn in. In the early days of American history, 7 in 10 Americans were legally barred from voting. 3/4 of the states required ownership of property until 1850. Even in ancient Athens, the supposed cradle of democracy, strict citizenship requirements disenfranchised 80 to 90% of the population. Now moving on to the amendments, the first 10 amendments, or the Bill of Rights, was a big deal in 1791, and it still is. 12 amendments had been proposed initially. One of them on congressional pay eventually became the 27th Amendment in 1992. But look at that last bullet, that one amendment that was never ratified, and they imposed no time limit to do so. So currently it's still pending, technically. And right now we have 435 representatives in the House, and they represent about 711,000 Americans. If Article 1 had been ratified the way it reads, we would have 6,500 members of the House today, each of them representing only 30,000 people. So as you ponder that, 6,500 members of the House. I'll turn this webinar over now to our newly elected local league president, Sudie Watkins, who will take you through the fight for changes up to 2020.
Thanks, Mary Ann. We now look at those words, vote, voted, and voting. They appeared 39 times in the Constitution, and the phrase right to vote 5 times, all in the amendments, not in the original document. It is interesting that the rights to keep and bear arms, free speech, free assembly, and freedom of religion only appear once. Again, please focus on the fact that election laws are the responsibility of each state, and each state can and do run elections as they choose, 50 different ways. Don't panic, we'll only visit a few of these amendments today, but the Constitution began with about 4,500 words and is now a document with nearly 8,000 words thanks to the amendments. The dates in the list above are ratification dates. The right to vote wasn't specifically addressed in the Constitution until the amendments, as just mentioned. But that does not mean that the right to vote is less valued in the family of American rights. The four amendments in red, the 15th, 19th, 24th, and 26th, protect it using these words: the right of citizens of the United States to vote shall not be denied or abridged. Article 1 of the Constitution, known as the Elections Clause, gave states the responsibility of overseeing federal elections. That includes rules concerning public notices, voter registration, voter protection, fraud prevention, vote counting, and determination of election results. But how they run elections varies. Until the 1980s, each state set its own date for election, and the voting requirements in each state have changed through the years. Congress may pass federal laws regulating congressional elections that automatically preempt any contrary state statutes. The framers of the Constitution were concerned that states might establish unfair election procedures or attempt to undermine the national government by refusing to hold elections for Congress. They empowered Congress to step in and regulate such elections as a self-defense mechanism. As an example, Congress has exercised its power to make or alter rules concerning congressional elections by establishing a single national election day for congressional elections and mandated that states divide themselves into congressional districts rather than electing all of their representatives at large. Congress also has enacted statutes limiting the amount of money that people may contribute to candidates for Congress, requiring that people publicly disclose most election-related spending, mandating that voter registration forms be made available at various public offices, and requiring states to ensure the accuracy of their voter registration rolls. The 13th Amendment abolished slavery in 1865. Some claim otherwise. 9 states use that phrase, except as a punishment for crime whereof the party shall have been duly convicted, to develop a convict leasing system that began after the Civil War and continued until the 1940s. A theft of $10 was grand larceny. Vagrants could be arrested, and once convicted, felons could not vote. The Civil Rights Act of 1866 invalidated these so-called black codes, yet the Jim Crow laws of Reconstruction continued. Denying the vote to felons continues today. Has Florida been a model voting rights state? From 1868 to 2018, if you are convicted of a felony, you were barred from voting for life. The definition of felony still varies by state today. In 2018, a voting rights restoration for felons initiative in Florida passed with 65% of the vote. 1.4 million with felony convictions, excluding murder and sexual abuse, should have been eligible to vote. But the state then required that felons pay all fines and fees first. The matter of those fines, constituting a modern-day poll tax, has still not been resolved. An appeals court will hear it this August. The Due Process Clause of the 14th Amendment is the source of an array of constitutional rights, including many of our most cherished and most controversial. When it was adopted, the clause was understood to mean that the government could deprive a person of rights only with due process. The 14th Amendment protects the fundamental right to vote, barring states from needlessly imposing substantial burdens on that right. In order to vote, a court must determine whether it is a reasonable regulation of the electoral process under the Elections Clause, or instead undermines the right to vote. Laws requiring people to register to vote in advance of elections or mandating that they vote at their assigned polling places are exactly the types of restrictions that the Election Clause permits. Now we look at voter registration. When the Constitution was ratified in 1787, there was no such thing as voter registration, and it is still not common in the rest of the world. The 13 original states allowed immigrants to vote in 38 states until 1926. Now, in every state except North Dakota, citizens must register to vote, and laws regarding the registration process vary by state, as does purging voter registration lists. In Louisiana, for example, you were removed from the voting rolls if you left your home parish for longer than 90 days. 22 states now permit same-day registration, and Virginia joined that group on July 1st, 2020. In 1870, the 15th Amendment stated that the right to vote was not to be denied by race. It was the last of the so-called Reconstruction Amendments. Along with the 13th and 14th, they were designed to establish political equality for all Americans. This amendment granted Black men the right to vote, but what was the reality? Convicted felons could still not vote, and discriminatory practices, especially in the South, kept Blacks away from the polls. Let's look next at some of the Jim Crow laws prevalent at that time. For about 100 years after the Civil War, the Jim Crow era existed. Jim Crow was not a real person, but a contemptuous term for a Black man. It was based on a minstrel show character and meant to marginalize Blacks. The so-called Black codes worked in conjunction with labor camps for the incarcerated, where prisoners were treated as enslaved people. Black offenders typically received longer sentences than their white equals, and because of the grueling work, often did not live out their entire sentence. The KKK, that began at this time in 1865 in Tennessee, was very active during these white supremacy years. Lynchings took place, and with the public frequently viewing them. Whites-only signs prevailed. Jim Crow laws defined the second-class lives that Blacks lived for many years after the Civil War, with segregated waiting rooms and bus and train stations, water fountains, restrooms, building entrances, elevators, cemeteries, even amusement park cashier windows. From the 1890s to the 1960s, many states in the US, especially southern states, administered literacy tests to prospective voters, supposedly to test their literacy in order to vote. In practice, these tests, along with poll taxes, residency and property restrictions, and intimidation, were intended to disenfranchise racial minorities. The infamous grandfather clause would allow you to vote if your father or grandfather could vote before 1867, but no Blacks could vote before 1867. At first, whites were generally exempted from the literacy test if they could meet alternate requirements, such as a finding of good moral character. These laws achieved the desired effect of disenfranchising African Americans and Native Americans, as well as poor whites. Payment of a poll tax was a prerequisite to vote in a number of states till 1965. Poll taxes of the time may not seem expensive at first look. In Texas, the initial cost was $1.50, or about $40 today. But in an economic system designed to keep non-white incomes well below average, these relatively modest fees were enough to shut out many minority voters, not to mention lower income whites. The 24th Amendment to abolish poll taxes was ratified in 1964 when poll taxes were still in effect in Virginia. Members of the local League of Women Voters in Williamsburg had just officially formed the year before in 1963, becoming the first integrated local league in Virginia, and our earliest members remember fighting against poll taxes then. In 1913, the 17th Amendment gave the power to elect senators directly to voters in each state and away from state legislatures. With the words, we hold these truths to be self-evident, that all men and women are created equal. The fight for women's suffrage in America began in Seneca Falls, New York in 1848. 72 years later, Most women in America were able to vote when the 19th Amendment was ratified in 1920. We celebrate the centennial of that this year. Black women had also fought for this right, but Jim Crow laws still denied the vote to many. Prior to the 19th Amendment, women had been able to vote in a few selected Western states, such as Wyoming. More about the amazing women who led this fight in our next webinar. Stay tuned. Please put August 18th on your calendar at 4 p.m. again for a look at the history of women's suffrage in America and how we stand on the shoulders of these suffragists today. The 23rd Amendment gave DC residents the right to vote in presidential elections, but the 23rd did nothing to provide them with a voting member of Congress. Their one elected representative has no voting rights in Congress, although DC has more residents than either Wyoming or Vermont. A recent vote in the House along party lines was in favor of DC becoming our 51st state. DC would now stand for Douglas Commonwealth after Frederick Douglass. Congress has retained power to govern the district since 1787. In 1964, the Civil Rights Act had been signed into law. It focused on segregation and employment discrimination and failed to fully address voting issues faced by Africans America. So 1 year later, the Voting Rights Act of 1965 expanded the 14th and 15th Amendments by banning the racial discrimination in voting practices that existed for nearly a century. The legislation provided for federal approval or pre-clearance of proposed changes to voting laws in many southern states that had previously used tests to determine voter eligibility. However, in 2013, the Supreme Court in Shelby County versus Holder struck down that pre-clearance requirement as unconstitutional, stating that those circumstances of discrimination no longer existed. The jury is still out on the accuracy of that belief. For example, since that decision, many jurisdictions that had been covered by pre-clearance stepped up their voter registration list purges. Photo ID has been a divisive issue since 2006, when many states began requiring them to vote. In 2012, Virginia lawmakers passed new election rules that required voters to present identification with or without a photo, and the state mailed voter registration cards to all registered voters. 10 months later, the Republican-controlled legislature approved of a more restrictive measure requiring photo IDs for in-person voting. But many argued that voter ID laws disenfranchise individuals who may not have access to photo identification and disproportionately impact low-income individuals, racial and ethnic minorities, the elderly, and many individuals with disabilities. A bit of background here on a Voting Rights Act that few of us may be familiar with. Until Calvin Coolidge signed the Indian Citizenship Act of 1924, Native Americans had an unusual status under Article 1 that refers to Indians not taxed and not counted in voting populations. In 1919, Native Americans who were veterans of World War I had been offered citizenship. The right to vote, however, was governed by state law. While the 14th Amendment had defined as citizens any persons born in the United States, the amendment had been interpreted by the courts to not apply to Native peoples. The Indian Citizenship Act finally granted citizenship to about 125,000 of the 300,000 indigenous people in the United States who were not already citizens. But Arizona and New Mexico still barred Native Americans from voting as late as 1948. There are two important Supreme Court decisions in the 1960s relating to legislative districts and the power of one person, one vote. That refers to one person's voting power being roughly equivalent to another's. In 1962, Baker v. Carr was a landmark Supreme Court case that arose from a lawsuit against the state of Tennessee, which had not conducted redistricting since 1901, even though their state constitution required it every 10 years. Wait a minute here. Okay. In the 1964 Reynolds v. Sims case, the Supreme Court established the principle of one man, one vote, and ruled that legislative districts must be roughly equal in population. Before that decision, some votes were more equal than others, especially in Alabama, where legislative districts ignored population and large urban areas were underrepresented. In the United States, the debate about lowering the voting age from 21 to 18 began during World War II. In this 1954 State of the Union address, President Eisenhower supported lowering the age to vote to 18. The debate intensified during the Vietnam War, when most of those subject to the draft were too young to vote, and the image of young men being forced to risk their lives in the military without the privileges of voting successfully pressured legislators to lower the voting age nationally and in many states. Georgia had already lowered the age to 18 in some elections, and I was able to vote in Kentucky at age 18. Did you know that Virginia is one of 17 states that allow 17-year-olds to register to vote and even vote in primary elections if they will be 18 by election day? 3 states allow 17-year-olds to participate in presidential caucuses. 6 states, Alaska, Hawaii, Idaho, Kansas, Washington, and Wyoming, allow 17-year-olds to participate in Democratic caucuses, but not in Republican ones. We include this slide for Jeopardy fans who might find these facts interesting. 5 countries allow 17-year-olds to vote, quite a few at 16. And some still set voting age at 21. And the Vatican does not allow cardinals older than 80 to vote for a new pope. Virginia placed second most difficult state in which to vote in a 2018 university study based on the time and effort it took to vote in recent presidential elections. Voter fraud is an accusation that is in the news a lot these days and has been used as an excuse to pass laws to suppress voting. However, it is virtually non-existent according to the most recent nonpartisan studies. Impersonation, for example, tarnishes approximately 1 ballot out of every 32 million. Virginia's recent General Assembly session relaxed the most stringent of these suppression practices. Many changes took place on July 1st. Voting by mail in Virginia just got easier, and many who are worried about voting in crowded polling locations during the COVID-19 pandemic will take advantage of this convenience. The first change listed here allows permanent sign-up for absentee voting without applying for it every election, and no excuses will be needed to absentee vote, either in person or by mail. More than 25% of the votes in the 2016 and 2018 elections were absentee ballots. Same-day registration may be permitted in 2022, and changes allow automatic registration at DMVs. Finally, oh, wait a minute here. I just lost my place. Finally, no photo IDs are now required. According to a 2012 study by Project Vote, approximately 7% of the US population lacks photo ID. This is especially true of lower income individuals, those under the age of 20, and ethnic minorities. Non-photo IDs will now include a current utility bill, bank statement, government check, or paycheck containing the name and address of the voter. League members have been registering high school students for years, and those applications should now be made available at all high schools and colleges. Are these 3 terms the same or different? There is a slight difference in interpretation. In 2020, 4 states, Colorado, Hawaii, Oregon, and Washington, will conduct their elections totally by mail. All mail elections have received heightened attention in the media these past few months. Liberals highly endorse the idea, claiming it allows people to do their patriotic duty without risking being infected by the coronavirus. Mail-in voting has resulted in little fraud in the 5 states that have used it for years, and a recent study at Stanford University found that voting by mail did not advantage either party and might actually increase voter turnout. Some, however, oppose mail-only voting because of the history of racial discrimination where ballots were, quote, lost in certain states. The conservative public policy organization, Heritage Foundation, claims that they have found 1,285 proven instances of voter fraud and that it puts elections into the hands of the Postal Service and away from the oversight of election and polling officials. But did you know that in Virginia, voters can trace their absentee voting on the State of Virginia website to verify that it has been received and when? Some have been critical of mail-in ballots, suggesting they could prove deleterious to Republicans' chances in November and open the door to widespread voting fraud, a claim that lacks evidence. All voters in every state but 2, Mississippi and Texas, had the right to cast mail or absentee ballots for the mid-year primaries after the pandemic led 14 states to relax their rules. Many states are extending those changes for the general election in November. Here again are the important dates to jot down, especially that October 23rd deadline to request an absentee ballot. But remember, you can request an absentee ballot today, online or by phone. It will be mailed to you to enable you to vote within 45 days before the election, beginning on September 19th. Check out the Virginia Department of Elections website, where you can easily register to vote, update your address so that it matches your driver's license, and apply for an absentee ballot. Here's the updated absentee and early voting website if you'd like to get a head start and get on the vote early list. But the important question is, what can you do to fight for voting rights? Susan B. Anthony has the best advice: vote. Someone, actually a lot of someone's, struggled for your right to vote. Use it. We believe that you may appreciate that right a lot more after watching this presentation. Next month in Civics 101, we will look at the fight for women's suffrage and celebrate the 19th Amendment in 1920.